Hallkot Zechia Matana, Chapter 1, Laws of Acquisition and Gifts. The purpose of these laws is to determine how a person acquires an ownerless article and the processes that he employs. They also explain the rules governing one who gives a gift, one who receives, and which gift is retracted and which is not. All these laws are explained in chapters that follow. 1. Whoever takes hold of ownerless property acquires any object found naturally in deserts, rivers, and streams, e.g. grass, trees, wild fruits, and the lack of ownerless. Whoever takes first hold of such an object acquires it. 2. When a person catches fish in the sea or a river, and similarly when he catches fowl or various wild beasts, since they are ownerless, he acquires them. He may not, however, hunt in a field belonging to a colleague. Nevertheless, if he snares an animal there, he acquires it. If fish, wild beasts, or fowl are in a vivarium, that means any type of tank, anything for a cage for an animal, belonging to another person, they belong to the owner of the vivarium. A person who snares an animal that is considered to be a robber, this applies even if the vivarium is large and effort is required to snare the animal. 3. However, a person who takes a fish from the net of a colleague at sea or takes a beast from a snare of a colleague set in the desert, this is prohibited by virtue of rabbinic decree. If the snare can be considered to be a container and the person took the fish or the animal from the container, he is considered to be a robber. 4. When a person spreads out a snare in a field belonging to a colleague and traps a beast or a fowl, he acquires it even though he does not have permission to do this. If the owner of the field was standing in the field at the time the animal was trapped and said, "My field acquires this on my behalf," the owner of the field acquires it and the owner of the shared snare does not acquire anything. 5. When fish jump onto a boat, they become acquired by the owner of the boat, for the boat is considered to be a protected courtyard. If it is not considered to be a moving courtyard, it is not considered to be a moving courtyard because the boat does not move on its own. It is the water that moves it. 6. When a convert dies without having fathered a Jew after his conversion, he has no heirs. Instead, the first person who takes hold of his property acquires it. A neighbor does not have the right to buy the property from the person who took hold of it because this is considered to be a gift. 7. The following must apply when there are two fields in an estate belonging to a convert with one boundary marker between them. If a person manifests ownership over one of the fields with the intent of acquiring it, he acquires it. If he manifests ownership over it with the intent of acquiring both it and the other field, he acquires the field over which he manifests ownership, but does not acquire the other field. If he manifests ownership over one field with the intent of acquiring only the other field, he does not acquire either of them. He does not acquire the field over which he did not manifest ownership because he did not manifest ownership over it. He does not acquire the field over which he did manifest ownership because he did not manifest ownership with the intent of acquiring it. If he manifests ownership over one field with the intent of acquiring it, the other field and the boundary marker between them, or if he manifests ownership over the boundary marker with the intent of acquiring both fields, there is an unresolved doubt with regard to this matter. If another person comes to manifest ownership over one of the fields itself with the intent of acquiring it, the latter person becomes the legal owner. 8. Similarly, when two houses are located one within the other, if a person manifests ownership over one of the houses with the intent of acquiring both it and the other house, he acquires only the house over which he manifests ownership. If he manifests ownership over one house with the intent of acquiring only the other one, he does not acquire even the house over which he did manifest ownership. Now, when a person takes hold over a deed of sale with the estate of a convert, within the estate of a convert with the intent of acquiring the land mentioned in that deed, he acquires only the document itself. He may use it to wrap around the top of a bottle or the 10. When the boundaries of a field belong to a deceased convert are clearly marked, when a person plunges a spade into the field in one place, he acquires the entire field. If the boundaries of the field are not clearly marked by plunging the spade into that one place, he acquires only a portion of which the team of oxen will pass when plowing before the team returns. A boundary marker and a chatzav, which is this term refers to a plant or tree with a very long and powerful roots. Joshua planted Eretz Yisrael to distinguish between the boundaries of the ancestral portion of one tribe from another. Okay, so a boundary marker and a chatzav used designate boundaries serve as a cutoff point with regard to the estate of a convert. Whoever manifests ownership over a field acquires only up to the boundary marker or the chatzav. 11. Whatever is considered to be significant to create a separation with regard to the distribution of pay is also considered significant to create a separation with regard to the acquisition of property of a deceased convert. What is implied if there was a stream, irrigation ditch, the like, the person seeking to acquire the field acquire only up to the stream or up to the irrigation ditch. Whatever creates a distinction with regard to the domain of the Shabbos creates a distinction with regard to the acquisition of property of a deceased convert. For example, a situation where a property domain or a Carmelis is interposed between two fields. Indeed, a distinction is created, even if two fields were separated by a domain that is considered a distinction with regard to the transfer of a bill of divorce. 12. Whenever a distinction is created with regard to the laws of ritual impurity, it also applies with regard to the acquisition of property of a deceased convert. What's implied, a person enters a valley. There's an object that conveys ritual impurity on one side of the valley, and the person does not know whether or not he has reached the place that is ritually impure. Wherever the person would be considered to be ritually impure is considered to be a separate entity from the field as a whole. 13. The following law applies when there is a large valley containing many fields, all belong to one convert, and there is no boundary marker, chatzav, or any other entity that creates a distinction between them. If one person comes and manifests ownership over a portion of the valley with the intent of acquiring the entire valley, he acquires all the land that is known to be owned by that convert. 14. When a Gentile sells movable property to a Jew who buys movable property, he acquires and transfers the property to the Mashiach or through transfers of funds. Different laws apply with regard to landed property. A Gentile does not acquire landed property from a Jew without a deed of sale, nor does he transfer property without a deed of sale, for he will not rely on anything but a deed of sale. For this reason, if a Jew purchased a field from a Gentile and he paid money for it, but before he could manifest his ownership over it, another Jew came and manifest ownership over it in a manner similar to that described above with regard to the acquisition of property of a deceased convert. The latter person acquires land, he must however repay the money to the purchaser. The rationale for the decision is that the Gentile abrogates his ownership of the property at the time he receives the money, and yet the Jew purchasing the land does not acquire it until the deed of sale reaches his hand. In the interim, the property is like property in the desert, concerning which the rule is whoever manifests ownership over it acquires it. 15. When does it apply? When there are no known laws enforcing enforced by the governing sovereign. If, however, the law of the governing sovereign and judgment is that only a person whose name is mentioned in the sale, who paid money for the property or the like, can acquire land, we follow the law of the governing sovereign, for we rule according to all the financial laws of the governing sovereign. Zechia Umatana, chapter 2:1. The property of a deceased convert who has no heirs, property that is earnest in a field that a Gentile sold to a Jew has not taken hold of it, or all governed by the same laws. Whoever manifests ownership over them using a valid chazakah to be described in Hilchos Mechir acquires them, with one exception, eating produce. 2. What is implied when a person buys landed property from a colleague and manifests his ownership over it by eating produce, he acquires it, as we have explained. But with regard to the acquisition of ownerless property or property of a deceased convert, even if a person eats produce of a tree for several years, he does not acquire the tree itself or the land itself until he performs the deed involved in the land itself, performs the task involved in the tree. An incident occurred when a woman ate the produce of a date palm for 13 years, and then another person manifests ownership over the tree by performing tasks involved in the tree itself. The incident was brought before the sage, and they ruled the latter person acquired it. 3. There are many acts that are performed by a purchaser to prove ownership of the property. There are many acts that, if performed by a purchaser to prove ownership of a property, are not effective, but when performed to manifest ownership over ownerless property belonging to the deceased convert alike, are effective in acquiring. What is the plight? A person finds large palaces constructed on property belonging to a deceased convert, or an ownerless property, if he paints them slightly or plasters them slightly, e.g. for a cubit or more opposite the entrance, he acquires them. 4. When a person makes a design in the property of a deceased convert, he acquires it. If he sets out mattresses in the property of a deceased convert, he acquires it. If he plows a field with the intent of leaving it fallow for the property of a deceased convert, he acquires it. When a person cuts branches of a vine or a tree or a frond from a date palm in the property of a deceased convert, if his intent is to improve the tree, he acquires the property. If his intent is to feed the branches to the animal, he does not acquire the property. 5. What is implied if a person prunes the branches of the tree up from both sides, we can assume that he intends to improve the tree. If he cuts only from one side, it appears that his intent is only for the branches. Similarly, when a person collects wood, grasses, and stones from a field, if his intent is to improve the land, he acquires it. If his intent is to collect wood, he does not acquire the field. 6. What is implied if a person collected both large and small branches, we can assume that his intent was to improve the land. If by contrast he collected only large branches and not small ones, we can assume his intent was to collect wood. Similarly, when a person levels the surface of a land, if his intent is to improve the land, he acquires the field. If his intent is to level a place to use as a grain heap, it does not acquire the field. 7. What is implied if a person takes earth from a high place and brings it to a lower place, it appears that his intent is to improve the land. If we see that he is not concerned with this and instead throws earth and stones anywhere without concern, we can assume that his intent is merely to level one limited area to use as a grain heap. Similarly, if a person opens up a flow of water into his field, if his intent is to improve the land, he acquires the field. If his intent is to catch fish, he does not acquire the field. 8. What is implied if a person made only a place for water to enter, it appears that his intent is to improve the land. If he made 2 openings, one for water to enter and one for water to leave, it appears that his intent is to catch fish. 9. When a person builds large palaces or property belonging to a deceased convert, another person comes and sets up the doors. Second person acquires the property. Incidentally, obviously, you hear palaces, you have to chop. We're talking about the Armei and Melech HaMashiach. Okay, the rationale is that the first person did not do anything with the land itself. It's as if he piled up stones on the land and an act that does not bring about his acquisition of the property, nor is his acquisition affected because by constructing the building, he made a fence around the land. Since this fence is not useful because the entrance to the building was wide enough that one can pass through it, setting up a structure of this building is not at all useful until one sets up the doors. 10. When a person spreads seeds in a row in a field, he does not acquire the field. The rationale is that at the time he sowed the seeds, he did not improve the field at all. And at the time the produce grew, the benefit came as a result of the natural course of events. This is not sufficient for an acquisition to be made. 11. If a partition existed within the property of a deceased convert, another person came and built another partition on top of the existing one, he does not acquire the field. This applies even if the first partition sinks into the ground, the higher partition is still functional. The rationale is at the time the partition was built, it was not beneficial. When it became beneficial, the benefit came as a result of natural course of events. 12. When a person manifests ownership over a property belonging to a deceased convert or ownerless property without the intent of acquiring it, he does not acquire it despite the fact that he built or erected a fence. 13. When a person plows on property belonging to a deceased convert under the mistaken conception that it is his own property, he does not acquire it. If he plows property belonging to one deceased convert while he thinks that it belongs to another, he does acquire it, for he intended that his deeds acquire ownerless property. 14. If a convert was holding security belonging to a Jew, and when the convert died, another Jew came, took possession of this security, it should be expropriated from him and returned to its owner. The rationale is that when the convert died, his lien on the article was nullified. 15. When a Jew was holding security belonging to a convert, the convert dies, and another Jew takes hold of the security, the creditor should receive payment for the money owed him from the security. If it is worth more, the second person acquires the remainder. 16. When is the when the security was not kept in a court belonging to the first person? If it was kept in such a court, the court acquires it on his behalf, even without his knowledge, as we explained with regard to an article that was discovered, and the person who takes hold of it afterwards does not acquire anything. 17. The following was upon when the convert dies and the Jews take possession of his property. If they take it, they cannot servants above the age of majority, they acquire their freedom. Servants below the age of majority become regarded as livestock. Whoever manifests ownership over them acquires them. We have already explained the manner in which a person manifests ownership over servants and acquires them. 18. The following was applied when it is rumored that a convert died and the Jews take possession of his property, and then it is then discovered that he did not die and he has a child, or that his wife is pregnant. They must all return their property. If they all return the property and then discover the first rumor had in fact been true, and the convert had died at that time, and his son died before him, or that his wife miscarried, whoever takes possession of at this time acquires the property. Those who originally took possession do not acquire it. Zechia Matana, chapter 3. When a person gives a colleague a gift, the recipient is not acquired until he takes possession through one of the legal processes by which a purchaser takes possession of a purchase. If the giver desires to give him movable property, the recipient must lift up the article before Mashiach on an article that one would not ordinarily lift up, or acquire that article through one of the other means through which movable property is acquired. If he is giving him landed property or servants, The recipient does not acquire them until he manifests ownership over them as purchaser would, or until a legal document recording the gift reaches his hand. If a verbal statement is not sufficient, the recipient does not acquire the gift, and either one of them still has the option of retracting. 2. When, by contrast, a creditor forgoes a debt or a colleague forgoes a debt to a colleague who gives him an object that previously had been entrusted to the recipient for safekeeping, such a gift is made final by verbal statement alone. Nothing further is necessary, as we have explained. 3. Similarly, if a person tells a colleague, "You owe me your money, give it to this person," until the recipient acquires, neither has the option of retracting. This applies whether he gives the recipient the money in payment for a debt he owed him, or whether he give it to him as a gift, and it applies whether the money had been given to the person to whom the giver was charged without making the gift as a loan, or had been entrusted him for safekeeping, as we have explained. 4. Just as regard to buying and selling, witnesses are necessary only to reveal the truth of the situation when there are claims in denial. So, 2. With regard to the waiver of obligation and gift, witnesses are necessary only because of liars. 5. Just as the seller must define the property that he sells, as we've explained, so too a person who gives a gift must define what he's giving. What is applied if a person writes to a deed to a colleague which states, "Land from my property is given to you," or writes, "All of my property is acquired by you with some exception," since he didn't identify the property he was giving, and the recipient did not know what he was receiving, the recipient does not require anything. The recipient may not demand that the giver give me the least valuable of your properties. Instead, he acquires nothing unless the giver defines the place that he's giving him. Different rules apply, however, if the giver tells the recipient, "I'm giving you a portion worth such and such in this and this field." Since he defines the field, if no, he did not define the portion of the field, the recipient may collect a portion of that value from the least valuable portion of the field. 6. The following was applied whenever a person gives a gift with a context of a conditional agreement, whether the condition was stipulated by the giver or by the recipient. Should the recipient take possession of and acquire the gift, the gift becomes binding when the condition is fulfilled. If the condition is not fulfilled, the gift is nullified, and the recipient must return the benefit that he derived. This applies provided the condition was stated in the proper manner. 7. We have already explained with regard to all conditional agreements concerning gifts, purchases, and sales. It is necessary that the condition be restated, and the positive dimension of the conditions to be stated before the negative, and that the condition precede the deed, and the condition is one that is possible to fulfill. If any of these factors is lacking, the condition is nullified as if it has never been stated. 8. Whenever a person uses the expression conditional on the following, unless it is as if he said that the transaction will take effect retroactive to the present time, he does not have to restate the condition. Some of the Gaonim have ruled in this manner, and this is also my opinion. My teacher ruled that there is no need to restate the condition or state the positive dimension on the condition first, except in case of divorce and consecration. There is no proof to substantiate this approach. 9. Whenever a person gives a gift on the condition that it be returned, the gift is vowed. The gift is vowed when a condition was made to return the gift to the article immediately, that it be returned after a specific time passed, that it remain as a gift for the entire lifetime of either of the giver or the recipient, or that it remain as a gift for the entire lifetime of another person. The above applies both with regard to movable property and landed property. The recipient may derive benefit from the gift for the entire time that is his. 10. When a person tells a colleague, "I'm giving you this ox as a gift on the condition that you return it," if the recipient consecrates ox and then returns it, it is consecrated, and he has fulfilled his obligation to return it. If, however, the giver tells the recipient, "I'm giving you on the condition that you return it to me," the ox is not consecrated, for implied in the condition by the owner is that he return to him an article that will be fitting for him to use. The same applies in all analogous situations. 11. It is forbidden for a Jew to give a Gentile a gift without charge. He may, however, give such a gift to a resident alien, as implied in Deuteronomy, "Give it to the stranger in your gates to eat, and sell it to a Gentile, or sell it to a Gentile. To a Gentile must be sold. It may not be given to a resident alien. A contract may be sold or given. The reason for this distinction is that we are obligated to sustain a resident alien. Is applied by Leviticus to stranger or resident, he shall live among you. 12. When a person gives a gift to a candidate servant or a married woman, it is acquired by the husband or the owner. There is, however, a distinction between the powers of acquisition. The servant's master acquires the article itself, while the husband acquires merely the right to the benefit from the article. 13. Even if a person gives a gift to a married woman, the condition that her husband have no authority over it, or to a servant, the condition that his master have no authority over it, the master or the husband acquires it. If, however, one gives a gift to a married woman or to a servant, and the giver stipulates that the gift itself may be used for only this or this purpose, master or the husband does not acquire it. 14. What is applied to when a person gives a gift to a married woman and tells her, "This money is given to you as a gift on the condition that you use it for clothing, that you use it for beverages, or that you do with it what you desire without the permission of your husband. The husband has no authority over it." Similarly, if the person tells a servant, "The money is given to you as a gift on the condition that you use it for food, drink, or that you use it to obtain your freedom, or that you do with it what you desire without the permission of your master," the master has no authority over it. The same principles apply in all analogous situations. 15. When a person gives all his possessions to a servant as a gift, the servant acquires himself. He becomes a free man. He then acquires all the other property. If, however, the master retains for himself even the slightest amount of property from movable property, the servant does not acquire anything. The rationale is that the deed is not a complete bill of freedom. The master retains some connection to the bill of transfer. Therefore, the servant is not freed, and since he is not freed, he does not acquire anything.